Good morning and welcome to today's webinar. Today's topic is Perils of the Pandemic, Protecting the Rights of Credit Unions in the Bankruptcy Filings, and will be presented by Milos, Laura, and Jason, all attorneys of our bankruptcy team. Before we get started, I would like to take a moment to go over a few housekeeping items. My name is Adina and I will be the webinar organizer for today. We want to make sure that today's presentation is extremely valuable for you. So we ask that you submit all questions by clicking on the question button in the control panel and typing all the questions there. Your questions will only be visible to me, and I will collect all submitted questions, and we will do a Q&A with the presenters at the end of this presentation. Now for the main event. I would like to turn it over to Milos, but I want to make sure everyone could hear me. Could everyone hear me okay? Okay, perfect. Some people were saying they couldn't hear me, so I just wanted to make sure we were good. Perfect. Thank you, everyone, for responding. Now for the main event, I would like to turn it over to our first presenter, Milos. Milos, take it from here.
Thank you very much. First off, I would like to start by welcoming everybody to today's webinar. We're all undergoing a once-in-a-lifetime experience here with this pandemic, hopefully once-in-a-lifetime experience. And we decided to kind of start putting on some regular webinars as a firm just to kind of help guide our clients in different areas as everybody is working through dealing with this pandemic. Not only is it affecting our professional lives, but our personal lives as well, and it's become quite an adjustment. One thing to keep in mind, everything that's happening is very fluid. Nothing is sustained. Rules and procedures change daily and sometimes even hourly. And just want to let you know that with regards to the court issues and court updates, we've been pretty proactive as a firm, keeping on top of changes in the rules, compliance issues to make sure that we're transitioning through this pandemic without any issues. And then obviously we're letting our clients know as things progress and change. That being said, if you could, Adina, if you could move to slide 3. From a bankruptcy standpoint, bankruptcy courts are still functioning at 100%. There's been no interruption in services by the court or by our firm. The cases in bankruptcy are still being filed. One thing that you have to remember that makes bankruptcy unique from other types of cases that we deal with here is that the debtor initiates the case, where the creditor, under collections, creditor is typically the one initiating the case. So a lot of the rule changes that the state courts have imposed has put limitations on creditors to protect the debtor. In bankruptcy situations, the debtor has pretty much agreed to participate in the bankruptcy voluntarily. So there's been no restrictions on the procedures or processes or deadlines. So when a bankruptcy is filed, everything moves forward as normal. There have been some tweaks in terms of hearing attendance and in-person attendance for things, but for the most part, the cases are moving along at the same pace that they were moving along prior to the pandemic. That's important because the deadlines are still need to be followed. Don't make any assumptions that a court deadline is not a firm deadline with the pandemic. So if you miss a deadline, you still run the risk of being penalized for missing that deadline. But that being said, courts have been much more willing and accepting to asking for extensions of deadlines if there's delays caused by the pandemic that would prohibit you from filing something timely. The key there is don't ignore things and communicate to the court, through us, or if you handle certain things on your own, just to kind of keep them abreast of what's going on and don't simply assume that you can fix it down the road and use the pandemic as an excuse to an extent. One thing to encourage during this whole webinar is the questions. We will save questions for the end, but if you do have questions that come to mind so you don't forget them, please ask them right away. If you look at your webinar screen to the right, there's a little chat box. As you have a question come to mind, please put it in there and we will address it at the end of the webinar. If we can, Adina, if you can move it to slide 4. Actually, you know what? You can skip right to slide 6. The other thing to keep in mind here is if you have any questions whatsoever, we are 100% fully functional. We had no interruption of service as a firm. So if you hit any kind of bumps, snags, have any questions, or are unsure about anything through this pandemic, please feel free to reach out to any attorney or staff that you're comfortable reaching out to, and we'll be able to answer any questions for you or guide you through the pandemic or the issues that you're having. One of the things that I think we're all dealing with here with this pandemic is the fact that the change in the way we're working, right? I think our firm, and just from my discussions with most of you, everybody's pretty much going remote, or they're having very limited access to their office to access files and documents. I think we're all in a process now where we're trying to figure out the best plan to kind of address this currently and in the future. And I think one of the issues that I've come across with a lot of the credit unions is accessing documents that are needed to submit to the courts. Original or copies of loan documents, copies of titles, access to file information. And I know that we're kind of working through that. One of the things, like I said before, is if you have a situation where you cannot access a document or not provide information timely, that is fine, but you have to communicate that so we can properly request an extension. One of the things, too, that we felt that if you're not taking advantage of, that you should take advantage of, is signing up for these electronic court notices. Adina, if you could move it to slide 7, please. The court allows you to sign up to receive electronic notices from the court. And I know a lot of you have done that. Some of you have not. What that essentially means is you are agreeing indefinitely to receive court notices electronically. If you look at the slide on the screen, there is a website that the court has. You go to the website and you sign up through the website. It has step-by-step instructions, and you kind of follow the instructions, put in the information, and then once you're completed, it will start sending you notices via email for any kind of bankruptcy filing, or if any active cases, there are any notices issued by the court. So that would include situations where debtor files for bankruptcy petition and they list you as a creditor. You would get notice of the bankruptcy filing electronically instead of via mail. Obviously, I think that would have benefited you prior to the pandemic, but now with the situation where you cannot access your office physically or possibly check mail in a timely fashion, receiving electronic notices would be a tremendous help. A couple of things to keep in mind. The electronic notices are just the court notices. It's not a replacement for the electronic docket. So if something's filed by a third party, such as any kind of motions or objections, you will not get that electronically. The only notices you're getting is what the court would issue. So that would be the notice of the bankruptcy filing, notice of the bankruptcy meeting of creditors, the deadline for the proofs of claim, the deadline to object to the discharge. It's not a complete replacement for the actual docket, but it'll give you those important early deadlines and the court-imposed deadlines so you're aware of what's going on with the case. Obviously, that's important because you want to know if somebody's filed for bankruptcy, so if you have any kind of collection or garnishment or you're taking money from them, you're not running afoul of the automatic stay. The other thing to keep in mind is when you sign up for these electronic notices, you're going to receive these notices electronically. So you have to make sure that if you designate an email for you to check the electronic notices, that email has to be accessible and checked daily. Because if you're not checking that daily, it doesn't serve its purpose. I think generally a good idea, and what some of you have done that I've seen, is you set up a designated email address and an email box strictly for bankruptcy notices. And then you collectively as a staff, assign a team or a couple people to check the email pretty regularly to make sure that the electronic notices are being received and processed timely. If you do use an individual person's email, that's fine, but be aware if somebody's gone for an extended period of time, vacation, or if they leave employment with the credit union, that email needs to be updated and changed. When you sign up for the electronic notices, the other thing to keep in mind is they do require that you have all of your previous names and addresses, including names of any credit unions that have been acquired or merged with yours. So if your credit union has undergone name changes or absorbed any other credit unions or has had multiple address changes, make sure to have all that information available to you when you sign up for these electronic notices, so they know when a bankruptcy is filed, if they're using an old address, an old name, or a credit union that's been absorbed by you, that the court knows to send the electronic notices to you currently. I think with regards to electronic notices, that's the only things that I had to go over. Obviously, if there's any questions, please ask the questions, and we can save those for the end. And I will go ahead and pass this to our next panelist, Laura.
Hi, everybody. This is Laura, and I'm here today to discuss something new that you're probably going to see when you do receive these notices from the court on Chapter 13 cases. This is the Chapter 13 moratorium on planned payments. What this is basically a legal authorization to postpone planned payments due to this COVID-19 epidemic. Now, under normal circumstances, in a Chapter 13, and when I'm talking normal, I'm talking what all of our lives were like prior to this, COVID-19 pandemic, a debtor could always request a suspension or a modification in their Chapter 13 planned payments. They would do that by filing a motion. Then there'd be a 21-day objection period before the court would issue an order. It would typically take about 25 days, approximately at the earliest, before that order would actually be issued. These requests to suspend or modify planned payments, they were typically granted because there was legitimate change in circumstances. However, now, due to this pandemic, the courts are responding to this pandemic and that expected interruption in employment by trying to, some of the courts are trying to streamline this procedure to expedite it so that people don't become behind in planned payments immediately. So they've created a process to expedite the suspension and modification of planned payments. And the way they're doing that is, let me first say that not all courts are doing that. So in Ohio, in the Northern District of Ohio, it appears that most of the courts are still using the temporary modification procedure. In Cleveland, Canton, Adina, we're on slide 2 at this point. Okay. And I think we actually skipped the first one. I apologize about that. But the normal temporary modification procedure, Cleveland, Canton, Toledo, and Youngstown, they still file the motion with a 21-day objection period, and then the court will issue that order. Next slide, please. However, in the Northern District of Ohio in Akron, and also in the Southern District of Ohio, which is Cincinnati, Columbus, and Dayton, they are doing something to expedite that procedure. In Akron, they are doing it by an administrative order that is issued by the bankruptcy clerk. This is done without being submitted to the judge, and the moratorium is no more than 60 days. Once that administrative order is issued, creditors have a 14-day to file a motion to reconsider in response to that. The moratorium is effective the date of the order of the administrative order. Next slide, please. However, in Southern District of Ohio, they've done things a little differently. they're doing it by an agreed order, and the agreed order for the moratorium to either suspend or modify plan payments is 30 to 60 days. And the trustee's office in the Southern District of Ohio has actually provided a form for debtors' attorneys to use so that they can get this done as quickly as possible. Once this agreed order is filed, creditors have a 21 days to object to the terms of that agreed order. And this agreed order, again, is effective the date of the order. Now, in either, whether it's the Northern District or the Southern District, they still can file a motion to temporarily suspend plan payments, basically the normal way. But where it's possible to do it expedited, I'm sure that that's probably the way that you're going to see that done. In regards to the objections, next slide, please. One more slide, please. Thank you. Objections. The Chapter 13 trustee will probably not be very aggressive in objecting to any of these requests for the suspension or modification of plan payments, given the nature of this pandemic that's going on. Even if you have a situation where the debtor was behind in plan payments, they're going to probably be very lenient with this and not object. Part of the reason is of the CARES Act that was put into place. And this will actually allow the debtor to request a post-confirmation modification of their plan to address any feasibility issues. I know Jason's going to address the CARES Act after me, but basically what this is going to allow is plan payments to go beyond the 60 months to address those feasibility issues. I would think, though, it's probably in this situation because of this, just the effect that this pandemic has had on everybody's work situation and so forth, it's going to be very difficult to object to any of these temporary modifications due to COVID-19. Because we are expecting that they do have to, you can't just blanketly request it. You have to, in your agreed order or motion, you're going to have to, state what the situation is and what your interruption in employment was, whether you've had a reduction, whether you've lost your employment, so forth. So it's going to have to be substantiated. It's not something that is just automatically granted just because you asked for it. You are going to have to substantiate it, just as you had to in the past whenever you asked for any type of suspension or modification in plan payments. Next slide, please. And I guess probably when you're getting these notices, and you probably have already had some, because I've noticed when I check my ECF mailbox, I'm already getting notices that people have gotten their moratorium granted. You want to know what's happening next. Well, you need to be aware that you may not be getting plan payments during this time, because if suspension you're not going to, if it's modified, you may be getting less of a plan payment. What you can expect, though, down the road is that you're going to have to see some motions to modify the plan, because they're going to have to address these feasibility issues, because basically you can't go longer than 60 months in a plan payment. So when you get these modifications, make sure that you're protected by receiving monthly plan payments pursuant to this modified plan. Then, once you have that and we're past all of these moratoriums and plan payments are to resume, if your plan isn't being abided by and you're not receiving plan payments, then things will be back to normal, and we can file these motions for relief from stay if necessary. But it's time. There's so much that is going on. I think everybody's going to need to be a little bit patient with some of this, and everything's changing so quickly that I'm more than happy to. And I know we're working remotely and things are kind of up in the air the way things are handled, but you can always reach out to me. I mean, I've had a lot of clients, emailing me, some phone calls, but more through email, because we all are remotely. But if you have questions, what's happening, what's going on, how to handle this, I'm always more than happy to get back with you, because it can be confusing. I mean, it definitely can. And now you're getting, these notifications that these plan payments are being, suspended for these time periods. And it's something that, we just all have to just be patient with, and it will get back to normal, but things are going to be just a little bit different. And that concludes my section. Jason?
Hello, this is Jason White. As many of you know, I'm a bankruptcy attorney in the Cleveland office. I've had the pleasure of working with many of you over the years, and I hope all of you are healthy, safe, and adjusting well to the current situation. And that the same goes for all of your families and coworkers. Adina, let's go to slide 16. Okay, so the CARES Act was the federal economic stimulus package that was passed in late March after a unanimous vote by the Senate. This was done relatively quickly, and what the Senate did was they actually took an existing tax relief bill, which had been passed by the House of Representatives back in January, and the Senate just amended that to add all of the coronavirus economic stimulus provisions. The total amount of the aid package is estimated to be at least $2 trillion. It is the largest economic stimulus package in history, dwarfing the Emergency Economic Stabilization Act in 2008, which created the TARP bailout program. Aside from the sheer magnitude and size of the appropriation, there are a lot of other differences between this and the bills which were passed back in 2008 and 2009. One of those major differences are the provisions specific to bankruptcy, and we're going to go over those today. Next slide. Student loans. Odds are, if the debtor is a college graduate, they have probably already defaulted on their federally guaranteed student loans, and their biggest creditor is the United States government, specifically Betsy DeVos, the Secretary of the U.S. Department of Education, which provides the funding and oversight of the federal direct student loan program. A portfolio currently valued at approximately $1.5 trillion. The CARES Act says they are required to defer student loan payments, principal and interest, for 6 months through September 30th without penalty. Now, this only technically applies to the loans currently held by the Department of Education, not ones which were made by banks and merely guaranteed by the federal government. In order for those loans to actually be held by the federal government, most likely the borrower would have had to default on their student loans, which would cause the lender to cash out the federal guarantee and assign the loan back to the feds. Not surprisingly, a lot of the loans held by the federal government are in various stages of default, or were subject to some form of an income-based repayment program. Getting a 6-month reprieve on your federal student loan payments might make you less likely to file bankruptcy. But I'm not sure how effective that will be, since most people know they aren't going to be discharged anyways. The reason why this was included in the CARES Act was just to relieve some of the financial pressure on people. This is the federal government saying, don't worry about us, just focus on paying your other debts. That's a really big deal when you're talking about a $1.5 trillion portfolio. Second, post-confirmation modification. Laura has already gone over the Chapter 13 moratoriums, but this part of the law just gives the courts the authority to modify plans which have already been confirmed if the debtor has experienced a material financial hardship due either directly or indirectly to the pandemic. So if your hours are reduced, or if you've been laid off because of the pandemic interrupting your business activities, that's obviously one of these situations. In some of the courts, this is going to be automatic for a certain number of days, just because of an administrative order that they've issued or otherwise. And after the initial moratorium is expired, they have to file a motion to have that extended. In other jurisdictions, it's not automatic, and they have to file a motion to request it. And Laura's already gone over some of the differences between the courts in Ohio or just within the Northern District of Ohio. So all of these judges are pretty much doing things differently. And that might be the only thing that all of them have in common. The one thing this doesn't do is put a limit on the extent of the modification. It can either be a partial reduction or a complete suspension of the plan payments, depending on whatever the facts of that person's case are. Those of you who have a lot of Chapter 13 cases are probably going to notice this the most. The distributions you receive from the trustee are either going to get a little bit smaller, or they're going to stop entirely for at least a short amount of time because of that moratorium. Now, there is an opportunity to oppose their motions if it's in one of those courts where the judge requires them to file a motion. If we believe that the claimed financial hardship was either not material or was not due to the pandemic. For instance, if the hardship was pre-existing. But I think the courts are going to be granting these motions very liberally. And in that type of a situation, the burden of proof is going to be on us to actually produce evidence to show that it was not caused by the pandemic. So those might be pretty rare situations where we would actually know that and have evidence in support of it. Third, the stimulus check that you receive does not count as income for purposes of either Chapter 7 or 13. The last major bankruptcy reform passed in 2005 created that presumption of undue hardship analysis, which prevented debtors from filing a Chapter 7 if their average monthly income exceeded the average household income level for the county in which they reside. Excluding those payments, your stimulus check, requires the trustees and the courts to simply ignore that payment when they are doing this undue hardship calculation. As for the Chapter 13 debtors, this goes back to that disposable monthly income used to calculate how much your monthly claim payment is going to be. Congress just doesn't want you to get punished in a Chapter 13 for receiving the stimulus check they want to send you, which we all hope is going to be a one-time payment. So it shouldn't be used as a basis for determining what your plan payment is going to be by including that as income. Next slide. Fourth, the calculation of disposable income for purposes of confirming a Chapter 13 plan shall not include coronavirus-related payments. Now, this seems largely redundant from the previous paragraph where we talked about how it's not counted as income. And we have already mentioned the fact that the stimulus check wasn't counted as income. But you can have medical expenses due to coronavirus that cut into your disposable monthly income. Let's say, for example, you have health insurance coverage, where it gives you a list of the types of medical conditions they cover and a list of exclusions for conditions not covered. This is basically the bankruptcy equivalent of that. We aren't going to allow you to claim the benefit of those unanticipated coronavirus medical expenses in your disposable monthly income calculation for purposes of determining what your plan payment is going to be for the next 6 months. You've got your income and your expenses. Balance these things out, and that's how we determine what your disposable monthly income is going to be. By ignoring the expenses and ignoring the income related to coronavirus, we're basically just ignoring that this happened for purposes of figuring out what your plan payment is going to be at the end of the day. Unless your plan has already been confirmed. Then we're going to let you modify it because of the pandemic if your income has been reduced because of that. So, next item, number 5, the Small Business Reorganization Act, which was passed last year and gave small businesses the ability to file a more affordable version of a Chapter 11 bankruptcy case. The debt threshold for those was raised from $2.7 million and change to a whopping $7.5 million. So conceivably, if you have a lot of small business borrowers, more of them will be able to file a small business reorganization and avoid having to file a standard Chapter 11. Now, why would an eligible debtor want to file a small business reorganization instead of a Chapter 11? Because in a Chapter 11, you can't pay your unsecured creditors less than 100% without their consent and still retain the right to ownership of your business. But in a small business reorganization, you can do that. And the goal of almost every small business owner is to retain ownership of their company. Now, ultimately, payroll protection loans those small businesses are eligible for are probably going to prevent a lot of those small businesses from probably having to file bankruptcy in the first place. At least it should help prevent that. Last but not least, all of the changes mentioned above are going to sunset within a year. The student loan deferments, the ability to file a post-confirmation modification due to coronavirus reduction in income, all that goes away in March 2021. Next slide. Now, in addition to everything above, which applies to everybody, the CARES Act also had certain provisions which were applicable only to federal credit unions, not state chartered credit unions, just the federal credit unions. First of which is loan modifications for borrowers related to the coronavirus that would otherwise be categorized under the generally accepted accounting principles as a troubled debt restructuring. Now, I have to confess, I'm just a lawyer, not an accountant, so I don't feel qualified to explain to you what the GAAP standards are for troubled debt restructurings. But with that said, unlike the other provisions we discussed, this suspension of normal TDR rules only lasts until either 60 days after the national emergency is released, which, as far as I know, hasn't been released yet, or December 30th, 2020, whichever happens first. So if it was released today, they would have 60 days from today to continue the suspension of those GAAP accounting standards for troubled debt restructuring. If the national emergency continues until late October, November, then it's going to end up lapsing on December 31st. Secondly, extensions of credit from the NCUA Central Liquidity Facility. Those are not going to be approved unless you can show that you tried to use your primary sources of liquidity first. So your cushion of cash, your other highly liquid assets, or your ability to borrow funds on the market from other sources, those should be your first course of action. There's not a whole lot of detail in the statute about this. My interpretation of this is that they at least want you to try. As for what evidence is going to be required by the NCUA to show that you exhausted those primary sources first, the law doesn't specify what that evidence is. It just basically leaves the question to the NCUA itself to answer. My experience with examiners is that they don't mind getting questions. They don't mind answering questions as long as they know what the answer to that question is. So I would encourage people to put in a call to either the NCUA or your regional examiner if you have any questions about this, or we can talk about it offline. Next slide. So as we discussed, overall, the bankruptcy courts are making a concerted effort to continue operations as much as possible. Wet signatures on things such as reaffirmation agreements are being waived. In most jurisdictions, people are being allowed to attend 341 meetings and hearings before the bankruptcy judge telephonically. Prior to all of this, most bankruptcy courts required people to attend all hearings in person or make special requests in advance in order to be allowed to attend the hearing by telephone. And it was unheard of for the debtors to be able to attend the 341 meeting by telephone. For starters, they're sticklers about making sure you bring a copy of your photo ID and social security card to the hearing, and whether the wet signature on the petition was actually the debtor's signature. I participated in the telephonic 341 meeting last week, and the trustee just asked the debtor's counsel to email him a copy of the social security card after the hearing was over. That was it. So they're bending over backwards to try to continue operations as much as possible. Hearings on our motions for relief from stay, objections to confirmation in Chapter 13 cases, those are all being conducted telephonically. And the bottom line is everything is still going forward. They just don't want people to have to come to the courthouse and sit in a room with a bunch of other people. But the motions are still being ruled on and the discharge orders are still being issued. So, Adina, do we have any questions from the audience?
We actually do, so I'm gonna read them off to you guys. And everybody, please make sure you're sending in your questions to us so we could see them. So I'm gonna go with the first question, and this is in regards to the General Order 20/13, and this is from Texas Northern District. Secure debt is requiring the member to request this directly from the creditor, and then the creditor must file the paperwork with the bankruptcy court, ? Why? Wouldn't the debtor have their attorney request a modified plan and have them file the paperwork? Then the creditor would only have to object if they do not agree. So that was one of the questions.
Can you repeat the question one more time?
Sure. So this is a General Order 2013, Texas Northern District Secure Debt is requiring that the member request this directly from the creditor, and then the creditor must file the paperwork with the bankruptcy court. Why would the debtor have their attorney request a modified plan and have them file the paperwork? Then the creditor would only have to object if they agree.
I totally agree with that. The general order says what it says, however. I think in those situations, if they're requesting a modification of the ongoing payments or the continuing obligation that's going to be paid through the plan, if it requires a plan modification, it should be done by the debtor. So I'm just as mystified as you are that they're making us do that. If you send me an email, I can provide some further guidance about that. My email address is jwright, JWRIGHT @weltman.com, and we can work together to figure out how we're going to comply with that.
Okay. And then here's another question from the audience. How does this impact our members who are paying outside of their bankruptcy plans? Typically, if our members are paying outside the plan, we would try to get relief from stay to move forward with collection efforts if they miss payments. Do they still need to submit documentation with the court to allow for skipping payments, or can they go directly through the credit union?
I would, this is Milos, by the way. If you have a Chapter 13 plan where the debtor is doing a direct pay, they're still under an obligation to make that direct payment. So I would still approach all of these cases. I guess the ultimate thing is don't let the pandemic change how you're handling these cases. If the debtor is not paying on a direct loan, you still have a right to seek relief from stay. Now, obviously, given the circumstances, they may have a more reasonable excuse as to why they missed the payments because of the pandemic, and you may be more willing to work with them. Now, if they are asking for any type of a forbearance or a modification or anything along those lines, you can still discuss that with them, but I would probably recommend that it is discussed with their attorney directly, or at the very least that you get authorization from the attorney to speak with the debtor directly, because it may be easier just to negotiate the terms with the debtor, but I wouldn't do that without getting their attorney's, I'd probably say written permission via email, a letter, whatever. And then if you work out a loan modification, I would circle back and let the debtor's attorney know, and I would probably put the burden on them to make a determination on what, if anything, would need to be filed with the court, because it may require them to modify the plan. There's a bunch of different ways it would go.
All right. And Milos, there's another question for you on electronic notices. When signing up for electronic notices, it asks for additional names and addresses. Would this be our different locations We do occasionally get paper notices at several of our branches.
I haven't gone through the process of submitting the request completely, but I did research it and I did call their help desk. They indicated to me any names or prior addresses that have been used. So I would assume that that would include alternative addresses that are currently acceptable as well. So I think it's better to be more inclusive than less inclusive. So yes, I would include any alternative address as well, even if they're still currently good addresses.
All right. And it looks like if there aren't any other final questions from the audience, that concludes the Q&A portion for this session. Just the contact screen for all of our attorneys that were on today's call is up there. We will be sending everyone a copy of the slides because I know a lot of people like to reference the slides that were presented today. So I will be emailing those out for everybody. And make sure you visit our website because we are hosting webinars such as these every 2 weeks. So make sure you're on our website under events at weltman.com, and our latest webinars will be posted there. So thank you for attending this webinar, and this concludes the session today. Have a great day.